Thanks, Ken. I know I speak for all of us when I say that that was maybe the best presentation I've ever seen in my life, and I'm not just saying that because you're my new partner. And the guy who's not my partner, but I'd be proud to have him as a partner, is Todd Gale. He's from Dykema's Chicago office. Todd's practice includes focusing on litigation matters with an emphasis on complex commercial disputes, financial services litigation, and class action defense. He has tried cases before state and federal courts and arbitrators on matters related to contracts, real estate, intellectual property, unfair competition, antitrust, mass torts, securities fraud, and bankruptcy. He has also briefed and argued many appeals. Here to discuss the ethics of CFPB and the attorney-client privilege, here is Todd Gale.
Thank you, John. Good afternoon. As the new kid on the block and perhaps displaying its own newfound swagger, the CFPB has been fairly aggressive in terms of their statements of what they will do and won't do concerning attorney-client privileged materials that are turned over to them in investigations. Now, this can be contrasted with the Department of Justice's position over the last several years. One might recall that around 8 years ago, there was a McNulty memorandum that talked about charging of corporations at the Department of Justice that led to some consternation among our clients about when the attorney-client privilege there would be pressure from the Department of Justice to waive the privilege. Then in 2008, the Philip memorandum cleared that up and was very understanding and solicitous of the attorney-client privilege, understanding its historical roots, knowing that it makes sense for clients, whether they be individuals or corporations, to be able to share information freely with their lawyers at all points in time without the problem and without the concern that as time went forward, those communications might later be disclosed to the charging authorities, whether it's a regulator or whether it's an enforcer. The CFPB has come down in a very different direction. One might note, for example, that the SEC and the CFTC in 2012 came down much more on the side of the Department of Justice and made quite clear that they would not be forcing the waiver of attorney-client privilege in order to show cooperation during investigations by the SEC or the CFTC. The CFPB has not been that way. The CFPB has made much more clear that what they are going to anticipate in situations is when they request specifically attorney-client privilege materials, that those materials will be in fact disclosed and turned over. And the reason why that's so troubling is that sort of the two different hats that are worn by the CFPB. Remember that they inherited through Dodd-Frank the regulatory, the investigative powers of the prudential regulators, the Office of Controller of Currency, the FDIC, and so forth. They took that to a new level, though, when up until almost a year ago, they would come out for examinations and actually bring an enforcement attorney with them. So one could imagine why. Clients were understandably concerned that in these conversations, and based on the information that they were turning over, that they might be forced to turn over some attorney-client privilege materials. And remember how this works in the real world. It's not at all uncommon for a client early on, even before an investigation starts, to ask their attorneys to take a look at the landscape and let them know where their exposure might be. And if their attorney, if your attorney, were to write that down into a detailed memorandum, I don't think there's anyone in this room who would be comfortable having that very candid exchange between lawyer and client shared with the very entity that might enforce any potential violations of law. And so when the CFPB wears these two different hats, and when they come in, as the prudential regulators do, to do an examination, but they ask for this information, and then they say that they may use it in enforcement actions against that very entity, this is something that justifiably causes concern. Let's go back and talk for a minute about where the magic happens here. These are the specific statutes where it says that there is no waiver of privilege to disclose materials to your prudential regulator when you're a bank, and specifically when you're looking at 1821T, that the CFPB can share this information with other government agencies. Okay? This raises the specter of selective waiver. The question becomes, is this voluntary disclosure or is this compelled disclosure? By the fact that this statute exists, is that enough that later in life, when sued by, for example, a plaintiff's lawyer under the same sort of conduct, could you say, but wait a minute, I didn't waive the privilege here, this was compelled disclosure because this is my prudential regulator and the statute says that if they ask for it, I must turn it over. It's about as clear as mud at this point. We just don't know. Certainly the argument is, and the CFPB would say, that because there is a statute, that must be compelled disclosure. There is not legal authority to back that up beyond the statute. Now, when the CFPB came out with their final rule, I should back up a step. In January of 2012, they started with a bulletin. And in the bulletin, they clearly drew a line that was very different than the line that was drawn by the DOJ. They said that because we are also your regulator, if we ask for this information, we expect it. And if we think that this information should be shared with other enforcement authorities, we will share it. For example, you might remember that from Dodd-Frank, there is a new, it's now UDAP with 2 A's. It's a Uniform Deceptive and Abusive Acts and Practices Act. And the idea is that under this new UDAP law, that there's going to be some sort of uniformity where there wasn't before, when there were all these different 51 different state UDAP laws, in terms of what sort of conduct might be chargeable as a UDAP violation. Well, state attorneys general are also able to enforce those. And as you might know, the Illinois Attorney General, the New York Attorney General, the Mississippi Attorney General have already brought actions, primarily against debt collectors, but certainly in the consumer financial services space. So if, for example, the CFPB has done an examination, and if a state attorney general has decided to sue under this UDAP law, would the state attorney general then be able to go to the CFPB and say, when you did the examination of Bank X, did you get any attorney-client privilege materials? Did their lawyers do any examination at the front end before you came in and did your work to determine whether or not there were any potential violations of law? We'd like to see those, please. In the final rule, the CFPB did give at least some lip service to the idea that they would not willy-nilly just sort of turn this information over, that they would do so only when they thought it was important to the investigation or when there was a significant violation of law that potentially had occurred. But they also made clear that that would be their decision, that if they asked for the information, that it might have to be turned over, and once it was turned over, it was their decision to be made by their general counsel and not in consultation with the company that owned the privilege in the first place. Let me pause for a moment to give a little commercial for the attorney-client privilege and why it is important. Think about some other recent examples that have been in the news recently where other industries, not our industries, but other industries, came to not trust the fact that their regulators had their best interests at heart and came to perhaps not believe that the free flow of information between lawyer and client would work in everyone's best self-interest. Did that industry end up better or worse off? From my perspective, I think it makes a lot of sense to make sure that the fundamental historical reasons for the attorney-client privilege are recognized and that everyone, including the CFPB, bend over backwards to make sure that although they get access to all necessary facts, and that certainly no one would argue that any facts can be cloaked behind the attorney-client privilege or the attorney work product doctrine, that the analysis that makes up the privilege should not be part of the discovery. So, the CFPB says that, for example, they might provide the Department of Justice with evidence of potential federal crimes. They might provide the IRS with information about potential tax noncompliance. As I mentioned, they also could give over information to state attorneys general that are trying to enforce UDAP, the UDAP laws under Dodd-Frank. And we all know civil investigative demand can quickly become an enforcement action. At least once in May of 2013, the DOJ brought criminal charges against a debt settlement business. I keep coming back to debt collectors because the CFPB has them particularly in their sights. Frequently at events like this, you will see CFPB personnel come up and say that they get more complaints about the debt collection industry than they get about all the other aspects of the consumer financial services industry combined. I would argue that that is not a result of sort of the larger, more established companies, that is more the mom and pop and fly-by-night debt collectors. Having said that, though, this is something that's very much a focus of the CFPB and what they've been doing. So we end up with this new, potentially, culture of waiver. And when we talk about that, some of the problems are the potential for government overreach. I should be fair here and say that in the final rule, they did say, the CFPB did say, that they would not routinely ask for attorney-client privilege materials. I can also say that we have not seen just sort of a random occurrence of them asking for attorney-client privilege materials. The concern that I'm trying to articulate, I guess, is that there is not a valid reason why they should be different than the Department of Justice, for example. I think they are quite different from the prudential regulators, the OCC and the FDIC, because they're not just examiners, they are also enforcers of the law. And to the extent that they are enforcers of the law, when they ask for this privileged material to come over, not even as part of a cooperation plan, but just because they would like to see it and because they've asked for it, that creates real difficulty and puts a client in a very difficult situation. So how might one respond? I think when you boil all of these bullet points down, what it really comes down to is communicate very clearly. In the first instance, the lawyer and the client need to communicate clearly. The client needs to understand up front that if they are in the business of selling consumer financial products, that the CFPB might be interested in analyses that their lawyers do on their behalf. Knowing that can help people understand what sorts of analyses should be done. Certainly, we all need to represent our clients adequately. And we all need to make sure that the clients understand what the law is and how best they can keep their activities on the right side of the law. But none of us want to find ourselves in a situation where in a candid written communication with our client, we have pointed out problems that perhaps the CFPB will see differently when they look at our analysis elsewhere and in a different context. What it also means is when you're representing your clients before the CFPB, please be very specific and open with them and make sure that they understand that the underlying facts are not being hidden behind some kind of cloak of privilege, whether that be work product protection, whether that be attorney-client privilege. No one is trying to say that they don't get access to facts, and to the extent that we try to play cute and hide facts behind the privilege, it becomes much more likely, it seems to me, that we would end up having to give up the kind of legal analysis that none of us would be comfortable giving up. The last thing, and this is happening, the ABA has been out front on this for several years. Going back to 2007, even before the Philip Memorandum, the ABA has lobbied Congress and actually got the House to pass a bill talking about specific protections of the attorney-client privilege. It died there, and the Senate never really considered it. Recently, about a year ago, the ABA wrote an open public letter calling for executive action, for an executive order, explicitly recognizing that all federal agencies should respect the attorney-client privilege on the same level that the Philip Memorandum does for the Department of Justice. I appreciate your time this afternoon. Thank you.